Howdy, and welcome to another episode of Cooper's Code Lifecycle of a Case series, where we provide tools and tactics for the different phases of a case. We're compiling all of these episodes into a playlist on our YouTube channel, so head on over there if you want to see them all. In the final countdown to trial, we come to what is probably one of the most important phases of the case. That's pretrial work. And in the pretrial work, this is an opportunity to really help set the stage for the case. So there are a number of things that need to be exchanged pretrial: the exhibit list and the exhibits, the witness list, jury questionnaire, stipulations that one can agree to, motions in limine, a neutral statement or a decision to do a mini opening, and the verdict form. Those are kind of the biggies for a pretrial exchange. In federal court, the federal court will oftentimes require one to do a joint trial submission, where one has to go through a lot of these things and work with the other side to try and refine them. We oftentimes will try our own state variant of this with opposing counsel, where we'll reach out and suggest a joint submission in terms of what we can agree to, what we can't agree to. Two reasons for this. One is we find that when we go into a courtroom and we've worked together like that, the judge tends to be very appreciative, and an appreciative judge tends to let one try one's case, meaning you oftentimes won't get cut off on jury selection the same way. You just stand in better stead with the judge. Now, all that said, I'd say of the multitude of times that we have suggested joint work, it's accepted probably about 10% of the time. The other piece where joint work can be helpful is it means that one starts discussing these issues early on with the other side, and it reduces the number of duplicate exhibits. It means that one is more likely to get a jury questionnaire. So there's a number of benefits to it. A way to start this whole process is with the exhibit list. And that's making sure that everything that one might need in the case for trial has been listed on the list. There are various ways to handle medical records. Our approach typically is to take each visit as a separate exhibit. So, and this is, I will tell you, it's very time consuming. The benefit to doing it this way is it makes it a lot easier on the clerk. It makes it much less likely that something that you don't want to have comes in. And you can move to admit record by record in terms of what you want in versus what you don't want in. It also makes it much easier when you're working with an expert and asking the expert questions. Isn't it true that on blankety blank date, so-and-so went and saw thus and such person? I want you to turn to exhibit 32. And so it makes the trial just flow a lot better. The downside is you end up with an enormous exhibit list, and a lot of them are exhibits that don't get referenced during the course of the case. But it is always easier to have it there and have it be available than the other way around. So that's the benefit of pulling those all out. If you're very proactive, you can go ahead and get the medical records in chronological order, have them numbered with specific numbers, and use those numbers as the same numbers all the way through the trial. And then you can give your expert the binders with or digital versions of the binders that have all of these, so that they're making reference to the same numbers in their report as are being referenced in trial, and it smooths everything out. It's very streamlined when that works. There are lots of situations where the records just dribble in, and it's much harder to make that happen. Same thing with a running exhibit list through the course of a case. I would say there are probably less than 10 cases that I've been involved in where, starting with the first exhibit of the first deposition as exhibit 1 and running it up through 100, 200, 300, 400, whatever it is, through the course of discovery and trial has worked. Usually someone forgets to bring a binder, or someone forgets what number they're at, and the thing starts falling apart. That said, it can really streamline cases in the cases where you work well with opposing counsel and you can reach an agreement and have that just running exhibit list all the way through. So that's exhibit list. I'm going to talk about jury questionnaire before I talk about witness list. We usually like to use a jury questionnaire. We usually like to try and get buy-in from the other side on a jury questionnaire. One of the benefits of a jury questionnaire is a good jury questionnaire incorporates the witness list. So typically it's the last page of a jury questionnaire. You'll have a list of all the names of the people and entities who may be involved in the case, and it also includes the law firms and the lawyers. But that way the judge doesn't have to go and read through 42 names and ask people to raise their hand as to how they know, John Doe. It just kind of speeds things along. Jury questionnaires are also beneficial because people are much more likely to answer things honestly on paper when they're just writing it down rather than answering questions in open court that might be embarrassing. We find that a jury questionnaire is a wonderful tool to help us dig into things in a more meaningful way and go into jury selection in a more meaningful way. That said, there are a lot of judges who will not allow them in cases under a certain duration or in cases that they think are going to be under a certain duration. So try and get one if you can. Recognize you're more likely to get it if you could reach agreement with the other side, and recognize that there are courts where even when you're in agreement, they won't allow it. So witness list. The witness list is pretty straightforward. List everyone who you think may be called in the case. There are some jurisdictions where they will ask for a brief description of what they will be talking about and a time estimate. This gets harder. And the reason I say it gets harder is because sometimes when you're listing all the witnesses, you're doing it in a way where you want to make sure that you don't overlook anyone, even if there's a low likelihood that they're going to be called. You may think that you might need a radiologist for a Sanchez issue to lay some foundation, but realistically, the treating radiologist is not going to be called at all. It's just your expert ortho who's going to be testifying about things. The time estimates tend to be loose. We tend to overestimate time because it is always easier to overestimate the length of a trial and then come in under that time limit than have a judge telling you you are out of time and the jury's going to be going home, so you're doing closing tomorrow. So just consider that in terms of the time estimates. Stipulations, there are typically things that the parties should agree to without them having to be motions in limine. Things like witnesses not being in the courtroom until after they've testified, unless they're the parties, letting the other side know who you're going to be calling roughly 24 hours in advance, demonstratives in opening, no reference to mediation or insurance. These are all things that should be done and shouldn't be a fight. Sometimes with opposing counsel, you're going to have fights. So then you just have to have your stock motions in limine. So in the motions in limine department, there are stock motions in limine, the ones that you do in almost every case. An example here is, no new opinions from experts, absent appropriate notice to the other side. And then there are case-specific motions in limine, and these are ones where they can make significant difference in the outcome of a case, either by getting the court to order to allow certain evidence to come in or getting the court to order to keep certain evidence out. If you have these types of issues where you think it's going to be pivotal in a case, it is wise to start these early so that you're not doing it in the flurry of the tight window before trial. It also can be beneficial if you direct calendar judge, direct assignment judge, and you think that these things are going to alter settlement negotiations, to say so to the judge. And sometimes there'll be a pretrial conference, or there will be a final status conference. And that's an opportunity to say to the judge, hey, judge, as an aside, we've been to 2 mediations. We've made headway, but at this point, we're still headed to trial. There are a couple of evidentiary issues. If certain evidence comes in or if certain evidence is kept out, it's going to completely alter the landscape of this case. And with that in mind, We would love it if you would be willing to schedule a motion limine hearing early, say sometime in the next 2 weeks, so that we can brief these issues, get rulings on them, and then that may help us in a way where this case may not be in your court. Judges oftentimes will try to help you when they can as far as that's concerned. So neutral statements or mini opening requests. Courts now are obligated to allow the parties to do a mini opening should they choose to do so. There has been a lot written about mini openings versus neutral statements, whether one is better than the other. There are people who have very strong beliefs about one versus another. The short version of this is a mini opening is very different than the actual opening. A mini opening is an opportunity to be very fact neutral, to not be passionate or persuasive. And the reason for this is if you are a compelling trial attorney and you are passionate, what you'll find after your mini opening is a lot of your good jurors are going to end up getting off for cause because you have told such a compelling story. So the other approach that is recommended by most of the trial consultants at this point is, if you're doing a mini opening, to disclose in a fact neutral way some of the bad facts in your case that you want jurors to be thinking about, because then you start being able to get the people who are very much against your case. You can start focusing on them and getting some of those jurors off for cause. If you're going to possibly need a neutral statement, just recommend getting that done in advance. So there are some courts that will give you static about the mini opening. If you think you're going to get static, it's wise to have something that's agreed to beforehand so the judge is not writing something from the bench and choosing to write their own story just before the jury panel is coming in, which we've seen judges do sometimes. Final piece, verdict form. It is wonderful to have an agreed verdict form before you are trying the case. It is wonderful to have an agreed verdict form before closing. Sometimes the verdict form is simple. It's a, negligence, comparative negligence, and damages and two parties, and that's it. Sometimes things get complicated. So if it's going to get complicated, getting the judge's eyes on it early in the process, we like to use the verdict form as the frame for closing argument. And because we want to use the verdict form as the frame for closing argument, meaning you're going to get question one. Question one asks, was defendant so-and-so negligent? Here's the information that you need when you're in the jury room to be able to focus on answering this question. And when other jurors come up to you and say, gosh, I don't think they're negligent, you can say, but did you consider 1, 2, 3, 4, 5, the testimony of so-and-so, the photo of this? So the verdict form becomes a powerful advocacy tool for closing. So getting that agreed upon as early as you possibly can so that it's not being argued about while the jury has gone back to deliberate. That's something that is useful in the process. Moving from the pretrial documents to the trial phases itself. There is jury selection, opening statement, the plaintiff's case in chief, the defendant's case in chief, rebuttal witnesses, if any rebuttal witnesses are being called. There's closing, there's the deliberating, there's the reading of the verdict, and then there's polling. Of these phases, jury selection is the one that sometimes surprises people by how much time it takes. And I don't mean to be insulting in saying this. Having been a juror, it feels like a cattle call when one is being called in as a panel. So you get the call, group number 108, 109, 110, 111, go up to department 502, go down the elevator, take the elevator to the 5th floor. And so you shuffle along, you go up an elevator, and you go into a jury room with a bunch of other people wondering what the heck this is going to be about. So just waiting for the panel to come up and reading the names and making sure nobody got lost between the jury room and the courtroom can take, 20, 30 minutes. Then doing the hardships can also take an extended amount of time. If there's a questionnaire, then having the questionnaire filled out, going home, making copies, reviewing those, then coming back the next day to do the jury selection. So each part of this can take time. There was a period where some judges were limiting people to 15 minutes of questioning for jury selection. The arbitrary time limits are something that can't be done now by statute. One still sometimes comes across judges who limit time on jury selection, but on the whole, it's much better than it was, say, 10 or 15 years ago. As long as you don't look like you're wasting the court's time, oftentimes you'll be given the time that one needs to pick a jury. The jury selection process is fascinating. It is an episode unto itself in terms of how to do it. There's a lot of strategy, a lot of game theory, a lot of planning based on who one is losing or who one thinks the other side is going to be getting rid of. The short version of this is that most courthouses use what is sometimes referred to as the six-pack model, which means they'll have 12 in the box, that's the jury, and then 6 in chairs in front, and you'll question those first 18 people. You then use your cause challenges saying, Judge, I think jurors 4, 7, and 12 are off for cause. The judge will try to rehab them. There is a good case law on jurors not being able to be rehabbed once they say they can't be fair. It's an 1899 case involving the Tidal Railway. If you can't find it, feel free to reach out to us. We'll be happy to provide some briefing on that. But the goal is to identify people who you can get off for cause, get them to agree that they cannot be neutral and that they are not a good juror for this case and that they, in fact, can't be fair. It's a delicate process to get them to say those words, but if you have them say those words, usually they can't stay. And then after you do your cause challenges, there are peremptories. So each side gets 6 peremptories. You don't want to be in a situation where you're using that last peremptory and the defense has more remaining and suddenly you end up with a bunch of really terrible people who you can't get off for cause going into the box. But that's the macro. If you want the micro, I would suggest going back to the Ed Lazarus interview on jury selection that is from probably about a year or more ago, but he's a jury consultant who we've worked with and has some good input on the jury selection process. Opening statements are oftentimes referred to as the cover of a jigsaw puzzle. That's a very common line, but it's a way to tell the story in a coherent fashion so the jury understands what happened. Some people refer to it as opening argument, meaning there are people who will push the envelope on the persuasiveness in opening statement, even though it's supposed to be fact neutral. The common tactic in any opening statement, when you start getting objection argument sustained, then the common way that people handle that is they just go back and say, the evidence will show, and then they say the same thing. The evidence will show that the defendant's behavior was reprehensible. Objection argument, I said, the evidence will show. He said, the evidence will show. Go on, counsel. So after opening statement comes the case in chief. As an aside, this is an area in a modern case where we feel it is wise to have more than one attorney doing the lift. And the reason for that is going from jury selection to presenting a compelling opening statement to taking a meaningful first witness, which oftentimes is an adverse witness. It is frequently, say, the defendant's designated agent that one is taking as a cross-examination under Evidence Code 776, where you can lead the witness. And so it can be a very challenging examination. So those 3 things back to back can be a heavy lift. It can be great if the attorney doing jury selection can sit down, another can do the opening, and then that same attorney that did jury selection then does the first witness. Then you kind of scatter it as you go forward from there. There is an art to the order of witnesses. The art is to care deeply and also be open to outcome. There are beliefs about primacy and recency. And so when you can order the witnesses precisely the way you would like, it's really nice. it is important to have the first few witnesses really be ones that you want to have in that order. Realistically, between expert schedules, court schedules, and the other things that just occur in the nature of trial, oftentimes they don't come in from that point forward in the order that you would like. And it always all works out. And it always all comes in. It's like watching Tetris fall from a really good player. The holes all get filled and everything works out just fine. But you need to be mindful that there are judges who will tell you that if you don't have a witness, you rest. So if you're in one of those departments, make sure that you always have a backup plan. So the backup plan can be your plaintiff. The backup plan can be a video deposition that you're ready to hit play on should a witness fail to show up. But just be aware of the temperament of your judge and have backup plans for backup plans. With the defendant's case, usually the defendant's case is much shorter than the plaintiff's case. That's oftentimes because most of the witnesses that they might have called, you've already called under 776 as an adverse witness. The defense sometimes will ask for the courtesy of having their expert go out of order because of challenges with schedule. We try to be professional and we try to be courteous, and where it will not harm the flow of our case, we will allow something like that. There can sometimes be challenges for this. We would not want the defendant's neuropsychologist to be the first witness in the trial because there's no other time for that witness to go. That's where we would say, I'm so sorry, but you may need to play a videotape deposition or read it. On the rebuttal witnesses front, after the defense rests their case, done a lot of trials. I know rebuttal witnesses exist. I have yet to have been in a case where a rebuttal witness has been necessary. And I should go back for a second. After plaintiff's case in chief, the defense will oftentimes move for a directed verdict, and usually the court will it will be an oral motion and the court will deny it as a matter of course. On rare occasion, they may ask for briefing. If you have a judge where you think that's going to be a case, just think about staffing your trial appropriately so that you've got some research support so that you're not trying to oppose a motion for directed verdict at the same time that you're going to need to be preparing your cross-examination of the defendant's witnesses for the next day. Closing, we do try and build around the verdict form, and we try to make it persuasive. We try to make it compelling. We try to tell a story, stick to a theme. And what we really want to do is arm our jurors with evidence and citations to the evidence. When somebody in the jury room says that it's not the defendant's fault, here are the things you can show to them to help them understand. Because your jurors are, in essence, your counsel, the ones who are friendly to your side. You want to help them be the best advocates possible in the jury room. That comes from building that closing around the verdict form. Then comes the hardest part of the case, for many lawyers, I know for me, which is deliberation. So whether it's an hour or a day or a week, you sit there with your client, you watch the jury go in, you watch the jury go out, and at some point, and it's always at a point where you're not quite expecting it, you'll get a buzz or a phone call, or the bailiff will spot you and say, verdict. And then your heart shoots up to the back of your throat. I've done this many times. It has never done anything different. And you gather your client, you go in, you wait to hear what the jury has said. Regardless of what the verdict is, we tell our clients to try to be as expression neutral as possible. No cheering, no crying, no screaming, no fist bumping, just an acknowledgement that the verdict has come in. The judge will ask if you'd like to poll the jury. We always poll the jury. We poll the jury because we want to know which jurors were in our favor, which jurors were against. That's an area where it can become very useful if one is going to need to work on a motion for new trial because one is unhappy with the outcome, or if one is going to worry about the defense working on a motion for new trial and you want to help preserve the verdict. So getting that polling done is helpful. The other piece that's not listed here on trial phase is chatting with jurors. Oftentimes after the case is done, the judge will let the counsel go out and talk in the hall. This is the best focus group that one could ever have. It's where one can get feedback on what was useful, what was not useful, what worked, what didn't work. And one can start seeing where there may be issues in the case should there be a motion for a new trial. Thank you for tuning in. If you enjoyed this, check out our previous episodes. More will be coming soon. If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions you have for who you'd like to see on the show. To all of you doing justice out there, happy hunting.